She stood at the reception desk of Hargrove and Linden, LLP, and said the most reasonable thing a person could say in that situation. "Excuse me, I believe there may be an error in the brief filed this morning. The procedural grounds cited in Section 4 are going to get this case dismissed before lunch." The junior associate behind the desk looked up. His eyes traveled from her face to her coat, the heavy canvas jacket with the fraying collar, the scuffed work boots, the gray locks pulled back with a rubber band. He was 26, maybe 27, with the particular brand of confidence that comes from a Bay Street internship and a father who golfed with the managing partner. He smiled the way people smile when they are about to say something they believe is generous. "Do you have an appointment?" "I don't need an appointment. I need someone to look at page 47 of the Marchetti filing before it goes before Justice Okonkwo at 2 o'clock. He glanced at his colleague. She shrugged. He turned back. "Ma'am, this is a private firm. If you're here about a legal aid matter, the community clinic is on King Street West." He said it kindly. That was the worst part. He genuinely believed he was being helpful. No one in that lobby said a word in her defense. The receptionist returned to her screen. A courier near the elevator looked at the ceiling. A paralegal carrying a stack of binders walked past without slowing down. Not one of them could have imagined what was about to happen. Because by the time that courtroom went quiet at 2:15 that afternoon, every person who had looked through her would be staring at the floor. 48 hours earlier, the Marchetti case had looked like a guaranteed win for Hargrove and Linden. Raphael Marchetti was 61 years old, a construction developer who had built half the waterfront condominiums in downtown Toronto and owned the other half outright. He had the kind of money that doesn't announce itself. No watch that required explanation, no car that needed a second glance. Just a permanent stillness, the ease of a man who had never once had to check a price before ordering. His company, Marchetti Developments, was being sued for wrongful termination by a former VP of operations named Thomas Keene. Keene was claiming that his dismissal had been retaliatory, that he had been fired after raising internal concerns about a procurement irregularity worth $4 million. The case had everything: money, principle, and a paper trail that went in 3 different directions at once. Hargrove and Linden had assigned their top litigator, a partner named Douglas Fairmount. Fairmount had been practicing for 24 years. He was known for 2 things: a closing argument that juries described as surgical and an absolute intolerance for being questioned by anyone below the rank of senior associate. He had filed his procedural brief that morning. He was confident. He was always confident. And 4 blocks away, in a rented room above a dry cleaner on Spadina Avenue, a woman named Constance Obi was reading a copy of that brief on a laptop with a cracked hinge. She was 58 years old, black, with a jaw that held opinions without apology, and eyes that had been reading case law since before Douglas Fairmount had written his LSAT. She wore a canvas work jacket because the room was cold, and she hadn't yet replaced the lining she'd torn out in January. Her work boots were scuffed because she walked everywhere. Her locks were tied back with a rubber band because she was thinking, and rubber bands were what you reached for when you were thinking. The brief was good. It was professionally written, structurally sound, and almost certainly going to collapse on itself before the second day of proceedings. She had seen the same error before, not once, not twice. She had written the paper that identified it, published in the Osgood Hall Law Journal in 2003, cited in 11 subsequent federal court decisions, and still assigned in the constitutional law seminars at the University of Lagos, where she had spent a decade teaching before the administrative review that ended her career in Nigeria and sent her to Canada with a suitcase, a shipping box of legal texts, and the kind of credentials that Canadian bar accreditation committees had a particular talent for misplacing. She had submitted her documentation to the Law Society of Ontario 4 times. 4 times, her foreign credential assessments had been returned, delayed, or assigned to reviewers who never followed up. She had watched colleagues from the United Kingdom and the United States move through the same process in 8 months. She had been waiting for 7 years. In the meantime, she had taken work where she could find it, Paralegal support for legal aid clinics. Document review for a Bay Street firm that paid her contract rate and never learned her name. She kept a notebook where she still drafted arguments, still annotated decisions, still argued cases against herself in the margins of printed judgments. She read the Marchetti, brief to the end. Then she closed the laptop. Then she opened it again and read Section 4 one more time. The error was not subtle. It was the kind of mistake that looked invisible until it wasn't. A procedural citation that had been accurate in 2018 and was no longer binding after a federal court of appeal decision in 2021. Fairmount had anchored his entire motion to dismiss on a standard of review that the court had quietly shifted. If Justice Okonkwo was current, and Constance knew that she would see it in the first read. Keene's case would survive the motion. The discovery process would open. And once it opened, the procurement irregularity would become the story. She had no stake in any of this. She had never met Raphael Marchetti. She did not know Douglas Fairmount. She was not getting paid. She put on her jacket and walked 4 blocks to Bay Street. The lobby of Hargrove and Linden had marble floors and a reception desk that was designed to make people feel the distance between where they were and where the decisions were made. The associate behind it had excellent posture and the practiced neutrality of someone who screened visitors professionally. He told her the community clinic was on King Street West. She told him about page 47. He reached for his phone and called security with the efficiency of someone who had done it before. The security officer was polite. He walked her to the door. She stood on the sidewalk. The October air came off the lake with teeth. She pulled the jacket tighter and thought about the courtroom and the clock and Justice Okonkwo, reading Section 4 with her glasses pushed up and her expression perfectly still, because that was how Okonkwo looked when she had already decided something. Constance knew what she looked like from the outside. She had known for 7 years. She walked back to Spadina. Inside the Hargrove building, on the 31st floor, Douglas Fairmount was in his office, reading a research memo when his phone buzzed. It was his client. Marchetti's voice was even, the way it was always even. Not calm exactly, but compressed, like a man who had learned that volume was inefficient. "I need to ask you something directly," Marchetti said. "The woman who was just removed from your lobby, did anyone speak to her?" Fairmount set down the memo. "What woman?" "There's a camera above the reception desk. My assistant monitors it for security purposes." He flagged it to me. She wasn't a client. She wasn't announced. The team handled it appropriately. She was standing at that desk for 4 minutes. She said something specific about a section number. A pause. "What's on page 47 of your brief?" Fairmount felt something move in his chest that he would not have named if asked. "The procedural foundation is solid. I've built cases on this standard for 6 years. When was the last time you checked whether it was still binding?" The line was quiet for 3 seconds. 3 seconds was a long time in a conversation between men who made decisions for a living. Marchetti said, "Find her." It took his assistant 40 minutes. She had paid for the room above the dry cleaner with a money order. The landlord had a phone number. The phone number reached a woman at a legal aid clinic on Dundas who knew Constance Obi and said she'd walked in that direction half an hour ago. Marchetti drove himself. No driver. A gray Volvo that looked like it belonged to a high school vice principal. He found her sitting on the front steps of her building, eating a sandwich and reading a printed judgment with a pen tucked behind her ear. He sat down on the step below her without asking if he could. "My name is Raphael Marchetti," he said. "I think you know something about my case." She looked at him the way she looked at arguments she was about to dismantle, carefully, without hurry. "Your brief cites a standard of review from Dunsmuir," she said. "The Federal Court of Appeal moved the goalposts in 2021. Vavilov changed everything above the reasonableness threshold. If Okonkwo applies the updated standard, and she will, your motion fails. Keene gets discovery. Discovery gets messy." Marchetti was quiet for a moment, the kind of quiet that comes before a decision, not after. "Are you a lawyer?" "I was the head of constitutional litigation at Adeyemi, Obi, and Partners in Lagos for 9 years," she said. I've been waiting for the Law Society of Ontario to finish evaluating my credentials for 7 years. In the meantime, I do document review. He looked at the judgment in her hand. She had filled half the margins with pencil. Her handwriting was very small and very precise. Can you fix the brief? It's not a fixable brief. It's a wrong brief. You need a different argument. Can you make a different argument? She looked at him for a long time. Long enough that most people would have filled the silence. He didn't. Take me to the file room, she said. I need to see everything they have. They arrived at Hargrove and Linden at 6:17 in the evening. Douglas Fairmount was waiting in the lobby, and the expression on his face was the face of a man who had processed several emotions in rapid succession and settled on the one he could defend. Mr. Marchetti, I have to tell you that bringing an outside, he looked at Constance, an uncredentialed outside party into an active client file is a serious breach of. She's not outside anything, Marchetti said. She's here to help. If that's a problem, tell me now. Fairmount's mouth closed. It opened again. She doesn't have a license to practice in Ontario. She's not here to practice. She's here to read. Marchetti looked at him the way he looked at contractors who gave him excuses instead of solutions. Douglas, my case is on the line. If she sees something in that file room that changes the argument before 2 o'clock tomorrow, I want to know about it. I don't care what she's wearing. Fairmount looked at his associates. The senior one, a woman named Philippa Vance, studied the floor. The junior one looked at the ceiling. Nobody moved to back Fairmount up. He stepped to the side. Constance walked toward the elevator without a word. She had already forgotten he existed. The file room was on the 29th floor. It smelled of toner and the particular staleness of paper that had been sorted too many times by people who were working too fast. She sat down at the long table and started reading at 7 in the evening. She read through everything: the employment contract, the internal communications, the procurement audit, the termination letter, the original claim. She made notes in her notebook in the same small, precise handwriting. She asked for a printed copy of the 2021 Vavilov decision and a highlighter. She got both. At 9:40, Philippa Vance pulled up a chair across the table. She was 34, sharp-eyed, and had been watching Constance work for an hour and a half with an expression that had shifted from skepticism to something more careful. You worked on constitutional law in Nigeria, she said. Federal administrative review, primarily. Constance did not look up from the document. I argued before the Court of Appeal 4 times. 1-3. The fourth was a plurality decision that academics argued about for 2 years afterward, which I consider an acceptable outcome. Vance looked at the notebook. What are you finding? 2 things. Constance turned the notebook so Vance could read it. First, Fairmount's motion is dead on arrival. The standard he cited hasn't been operative since Vavilov. If you proceed tomorrow on those grounds, Okonkwo dismisses the motion and you hand Keene the discovery process. Vance was quiet. She had run the same research herself late the night before and found the same problem, and had composed an email to Fairmount at 11:15 p.m. that she had not sent because she was 34 and he was a senior partner, and the email was still sitting in her drafts folder. Second, she said. Second, you're arguing the wrong motion. Constance tapped a page. You're trying to get the case dismissed on procedural grounds, but the procurement audit Keene is citing as his whistleblower trigger. This is the original internal document. Yes? Not a summary? Yes, read footnote 9. Vance, read it. She read it again. He flagged the wrong irregularity, she said. He flagged what he found. But the irregularity he reported, the $4 million line item, was authorized. It's in the board minutes. Buried, but it's there. What he missed, and what no one in this file has apparently noticed, is the separate $40,000 discretionary account on the same page. That account has no authorization, no board resolution, no approval chain. It is completely undocumented. She paused. Keene filed a whistleblower claim based on a protected disclosure. But the disclosure he made was of something that was legal. He has the wrong evidence. His claim does not meet the statutory threshold under the Ontario Labour Relations Act for protected whistleblowing because the conduct he reported at board was authorized conduct. The room was very quiet. Which means, Vance said slowly, which means the wrongful dismissal claim has no statutory protection. Which means your client has grounds to dismiss not on procedure, but on merit. You don't need Dunsmuir. You don't need Vavilov. You need the board minutes and 45 minutes with Justice Okonkwo. Vance stared at the notebook. She looked up at Constance. The expression on her face was the same one Constance had seen on the faces of students in Lagos when something they thought was complicated turned out to have a clean solution. The particular relief of clarity. How did you see that in 40 minutes? I have been reading procurement law for 30 years, Constance said, and the footnote is on the first page. Douglas Fairmount appeared in the doorway at 10:30. He had come back. He stood with his jacket off and his sleeves rolled, and the look of a man who had been sitting with something uncomfortable for several hours and had decided to stop pretending he hadn't. He crossed the room and looked at the notebook over Vance's shoulder. He read for 2 minutes without speaking. Then he said quietly to no one in particular, "I missed the footnote." Constance said nothing. "I need to restructure the entire argument before 7 a.m., he said. It was not a question. "You need someone to restructure it," Vance said. She did not say anything further. She did not need to. Fairmount looked at Constance for a long time. The look was not an apology. Men like Fairmount did not apologize easily, and she had stopped requiring apologies from people like him a long time ago. But it was something. It was the look of a man who had spent 24 years believing his framework for assessing competence was accurate and had just received evidence that it was not. "What do you need?" he said. "The board minutes from 2019 through 2022, coffee, and someone who can type faster than I can." Vance raised her hand. They worked until 4 in the morning. Justice Okonkwo was not a dramatic woman. She entered the courtroom at Osgood Hall precisely at 2 o'clock and sat down and organized her papers in the particular, unhurried way that meant she had already done most of her thinking. She looked at Fairmount. She looked at the brief that had been refiled that morning. Emergency application, granted, with new grounds, new case citations, and an argument that bore no resemblance to the document from yesterday. She read the new submission for 7 minutes in complete silence. She looked up. "Mr. Fairmount," she said, "I want to understand the basis for the merit-based dismissal you're now advancing. Walk me through the footnote analysis." Fairmount stood. He walked her through it, cleanly, precisely, with a sequence of citations that landed in the right order. He had spent 3 hours the night before memorizing an argument he had not written, and he delivered it well, because whatever Fairmount's failings were, he was genuinely good in a courtroom. When he finished, Justice Okonkwo took off her glasses. "Counsel for the plaintiff," she said. "Do you wish to respond?" Keene's lawyer stood. He was a capable man. He had prepared for the wrong fight. He had spent 2 weeks preparing to counter a procedural motion, and the procedural motion no longer existed. He stood at the podium with the expression of someone who had arrived at a chess match to find the pieces rearranged. His response was adequate. It was not enough. Justice Okonkwo delivered her ruling at 4:17. She dismissed the claim. In the corridor outside the courtroom, Marchetti found Constance. She was standing near the window at the end of the hall with her notebook open, writing something. He didn't interrupt her until she capped the pen. "Thank you," he said. She looked at him. "I didn't do it for you." "I know." He paused. "You did it because it was wrong and you could see it." She didn't confirm or deny. She put the notebook in her jacket pocket. "Can I ask you something?" he said. She waited. 7 years. You've been through this system for 7 years. The Law Society. He chose his words carefully. Has anyone ever actually looked at what you've submitted? Someone looked at it. Someone filed it in the wrong folder. Someone marked it incomplete without specifying what was incomplete. Someone sent the reassessment notice to an address I hadn't lived at for 3 years. She looked at him without heat. These things don't happen to everyone. The data is quite clear about whom they happen to. Marchetti was quiet for a moment. "I sit on 2 boards," he said. "One of them has a working group on professional credential recognition. It's been meeting for 4 years without producing anything meaningful." He paused. "I think that's about to change." She looked at him with the careful attention she gave to arguments she was not yet ready to accept or reject. "I'm not interested in charity," she said. "Good. I'm not offering it." He pulled out a card and held it out. "I'm offering accountability. There's a difference." She took the card. What happened in the following months was not a single event. It was a sequence of small movements, the way a fault line shifts. Nothing visible on the surface until suddenly the ground is in a different place. Marchetti called in the working group. He had Constance's file, all 7 years of it, every submission, every review, every letter, printed and laid on the table at the first meeting. He did not editorialize. He read the dates aloud, the delays, the lost documents, the form letters, the responses that cited regulatory standards that did not exist in the regulations. One of the board members, a retired judge named Eleanor Bautista, put her glasses on and read the file from the beginning and did not speak until she reached the end. "This is not an isolated case," she said. It wasn't. The working group commissioned a review. The review found that over the previous decade, credential applications from lawyers trained in Africa, South Asia, and the Caribbean had an average processing time of 4 years and 2 months. The average for applicants trained in the United Kingdom and the United States was 11 months. Of the 41 applications that had been marked incomplete and returned without adequate explanation, 37 had been submitted by applicants of color. 9 had been lost entirely. Constance's file was among them, not once. Twice. The report went to the Law Society in the spring. It was not buried. There were people in that organization who had been trying to say exactly this for years and had been waiting for data that was impossible to ignore. The report gave them what they needed. The Globe and Mail ran the story on a Thursday. By the following Monday, 3 national bar associations had issued statements. A parliamentary committee requested testimony. Constance Obi received her license to practice law in the province of Ontario on a Tuesday afternoon in November. The letter arrived by registered mail. She signed for it standing in the hallway outside her apartment, still in her work jacket, because she had just come back from a shift at the legal aid clinic. She stood there for a long time. She didn't cry. She had imagined this moment many times in 7 years, and in every version she had cried, which told her something about what she had expected the reality to feel like versus what it actually did. What it actually felt like was quieter, like putting down something very heavy that you had carried so long you'd stop noticing the weight. She walked inside and set the letter on the kitchen table. She put the kettle on. She opened her notebook and wrote 1 line in the same small, precise handwriting she had used to fill 30 pages in a file room on Bay Street at 2 in the morning. Then she closed it and drank her tea. Douglas Fairmount requested a meeting 2 weeks after the ruling. He sat across from her in a coffee shop on College Street and was, for the first 3 minutes, the most awkward she had ever seen a senior partner be. Then he stopped being awkward and said what he had come to say. Hargrove and Linden is creating a new position. Senior Counsel, Regulatory and Constitutional Matters. The role was designed around a specific skill set. He paused. Yours. She looked at her coffee. You filed an emergency application and case argument in 6 hours, he said. I've been practicing for 24 years and I missed the footnote. You didn't miss anything. I've been practicing for 30, she said. He nodded once, the nod of a man accepting a correction he deserved. The salary is competitive. The office is on 31. You would supervise a team of 4 associates. He met her eyes. I will not insult you by pretending the last year went any other way than it did. I am asking you whether, in spite of that, you would consider it. She thought about it. She thought about the legal aid clinic on Dundas and the document review shifts, and the room above the dry cleaner and the notebook with 30 years of arguments in it, and the letter on her kitchen table in an envelope she hadn't opened again since the day it arrived. She thought about Philippa Vance raising her hand at 10:30 in the evening in a file room that smelled like toner without any career calculation, just because something was true and someone should say it. I have a condition, she said. He waited. Vance makes senior associate before the end of the year. He didn't hesitate. Done. Constance Obi walked into Hargrove and Linden on her first morning with a leather briefcase she had owned since Lagos. It was worn at the corners, and the brass clasp had been repaired with a strip of electrical tape that she had never gotten around to replacing. She wore a gray suit, good shoes, her locks down. She took the elevator to the 31st floor and walked to her office and set the briefcase on the desk and looked out the window at the lake, gray and still in the November morning, the kind of gray that felt like a held breath before something changes. She opened the briefcase. She took out the notebook. She had a 9 o'clock call with a client in 15 minutes, a constitutional challenge to a federal procurement regulation that had been poorly written and wrongly applied for 6 years. She uncapped her pen. She had been waiting a long time to get back to work. 3 weeks earlier, in a disciplinary hearing room on the 8th floor of the Law Society's building on Osgood Street, the name Douglas Fairmount had come up in a different context, not as a complainant, not as a victim. The working group's report had documented something else, separate from the credential review data. In 2019 and again in 2021, a senior partner at a major Bay Street firm had submitted letters to the admissions committee, raising questions about the credential standards used to evaluate foreign-trained applicants from certain jurisdictions. The letters had used neutral language, administrative integrity, quality assurance, but the jurisdictions they named were Nigeria, Ghana, Jamaica, and Trinidad, not Ireland, not Australia, not France. The letters were in the public record of the working group report. Fairmount did not appear at the hearing in person. His lawyer submitted a written response. It was carefully worded. It acknowledged the optics without acknowledging the intent. The committee reviewed the written response and the evidence and found that the letters had materially influenced the review process for at least 4 applications, including Constance Obi's. His privileges at the firm were suspended pending a full conduct review. His 2-year partnership retention bonus was frozen. He sat alone in the parking garage afterward in the gray Volvo that was not his, waiting for his driver. Nobody photographed him there. No one wrote about that part. But Philippa Vance was sitting in the office on the 31st floor at the same hour, writing a memo she had drafted 3 times before she was satisfied with it. The memo recommended the firm establish a standing pro bono partnership with the Credential Access Program that Marchetti's working group had funded. It recommended that 2 associate positions per year be reserved for foreign-trained lawyers navigating the accreditation process. She sent it to the managing partner at 5:15. She got a response in 11 minutes. Approved. She read it once, set down her phone, and went back to the file on her desk. On the window ledge behind her, propped against the glass, was a copy of the East African Law Review, Winter 2004 edition. She had ordered it 3 days after the night in the file room. It had arrived yesterday, slightly battered, from a second-hand academic bookseller in Edinburgh. The featured article was 31 pages. The author's name was on the cover in small type below the journal title, Constance Obi, Footnotes and Fault Lines, a practitioner's analysis of administrative review standards under conditions of statutory ambiguity. Philippa had read it twice. She planned to assign it.